May please, Your Lordship. Lordship, with the consent of other side, I beg to mention item number 23, Lordship.
23.
A report was called for from the Gauhati PS, Lordship, by certain the date of respondent number 2
Okay.
is yet to be received, Lordship.
Yes, ma'am.
Hmm.
That report earlier
Not yet received.
not yet received.
Okay, we'll adjourn it.
Lordship, may give me a date, Lordship.
The Bora Learned Counsel for the petitioner seeks an adjournment on the matter. The report called for from Hojai PS with regard to the supposed death of respondent number 2 has also not been received. Full stop. Issue fresh requisition for the same. Leave the matter after 2 weeks.
2 weeks.
After 2 weeks on a date to be fixed by registry.
You may fix a date, Lordship.
You can suggest. You can suggest.
Other report.
9 September.
Oblige.
Yes, please.
May it please your Lordship. Lordship, I beg to mention for listing of a bail application. Lordship, the charge is under 105. Despite not being directly implicated in the FIR, I've been arrested, Lordship.
Okay, file it.
40 days in custody. Tomorrow, Lordship, if possible. Deeply obliged.
Please, Your Lordship, I'm praying for a listing of a matter. The matter was fixed for today, Your Lordship. However, it is.
Bail application.
No, Lordship, criminal petition.
Criminal petition. Can it be day after tomorrow?
Day
Day
after,
after tomorrow or Friday?
day after two.
Day after.
Your Lordship, I beg to mention item 38 of supplementary list, Lordship.
Item
38 of supplementary list, Lordship. The counsel, Mr. P. Bodolo, is at Hyderabad, Lordship, due to medical emergency. And the list on 31st
Just a
of
minute.
August.
30.
August, Lordship, Monday.
Okay, we'll adjourn it. 30 item number
38.
38. Council makes mention on behalf of the leading counsel P. Borderline stated to be outstation. Full stop. Scan record is available. List the matter after how long? You
31st of August, Monday.
list the matter on 31/8.
Right, Mr. Lordship. Lordship, here, my lord, FIR at page 16.
Yes.
Today, my lord, 59 days, my lord. So, my lord, the FIR says that allegation of rape without her consent. My lord, in fact, they are friends, my lord. A victim, a complainant and the accused petitioner. And previous night, they have arranged a party at Hotel Lily, my lord, Lily Hotel. And both are under heavy drunken condition. So, my lord, in paragraph 6, my lord, I have stated, my lord. Paragraph 6.
Forwarding report is at page 19, ma'am.
19, my lord.
I'll see para 6.
Para 6.
Okay. According to you, this is the facts.
Facts, my lord, my lord, the FIR, in FIR, the complainant mentioned that he is not known to her, my lord.
Mhm.
But forwarding report, my lord, case 19,
Mhm.
that ground of arrest, serial number 4, my lord.
Mm.
The accused failed to provide a reasonable explanation of his presence at the victim's residence after dropping the victim's sister and her friend at the railway station. My lord, they are friends, my lord, but FIR says
Anyway, so
59 days, my lord.
it's 90 days or 60 days?
Yes, 90 days, ma'am.
You get the case diary quickly.
Yes, ma'am.
One more thing, my lord.
Get it
He
on
was
Friday.
apprehended on 26, my lord. but produced before the learned magistrate,
Okay.
28.
We'll see that.
That is
28.
or 28. In paragraph, my lord, the forwarding report, paragraph 3, my lord, the accused was apprehended by the security guard of the so and so. So, my lord, on the very date, my lord, 26, my lord,
Mm.
incident was on 27, my lord, but forwarded after 24 hours, my lord. This is also one of the.
We'll see everything. Heard Mr. Khandakar, learned counsel for the petitioner. P. Bhattakur, learned additional papers. The call for the case diary of Dispur PS case number 449 of 2026. Petitioner was arrested on 27/6/2026. 59 days already.
Already, my lord.
Let's stop. Get it on Friday, Dispur PS. List on Friday.
Friday, my lord,
You have some problem?
I have some problem, my lord. Don't- so-
2nd of September. Witnessed.
Friday or Monday?
7th September, my lord.
7th.
7th. I have some.
Not late for you. Okay, as you wish. 7th September.
7th. I'm the.
May I please, Your Honor?
Yeah.
You know, FIR is page number 10, Your Honor.
Athar Kandi.
You know, petition number 1 and petition number 2 have not been named in the FIR, Your Honor.
Mhm.
And one of the co-accused who was forwarded with, along with the petition number 1 has been granted bail by this honorable court, Your Honor.
Mhm.
I've annexed the order, Your Honor. It is at page number,
Lucky,
Lucky five,
these two persons are not named in the FIR.
yes, Your Honor.
Not named.
Exactly same footings as the person who has been granted bail by this honorable court, Your Honor.
What is the allegation?
You know, on,
So for missing cow. It's not.
under
Under-
Patakandi police station, you know, there is a village called Lalugao, Your Honor.
I know. That's right.
Petition number 1 has been
So,
reduced.
page number?
This is page number 81.
20?
Page number,
Microphone to.
FIR is page number 10, Your Honor.
No, FIR I've seen. The bail order,
Bail order 35, Your Honor.
35.
This person was arrested and forwarded along with the petition number 1 of this case, Your Honor. No, penalty. No, penalty.
Case diary was called for in this case.
Yes, Your Honor.
Here forwarding report is at page.
He has spent, say, how many days? 62 days,
81 days, Your Honor.
81 days,
Petition number 1, yes. 2 is 78 days, Your Honor.
51 and 71 days. There's no reference to any injury report, right?
Yes, ma'am.
The nature of the injuries.
Fix it because from Pathakandi. I can produce it on 2nd of September.
Hmm?
No, no.
Anyway. काम करो ये तो पेज 36 होगा अपनी पैरा 2 first 2 paragraphs ले लो first. First up. The present petitioners, though not named in the FIR, were arrested during investigation on 5/6.
Petition number 1 on 5/6, Your Honor, and petition number 2 on 8/6.
On 5/6/2026 and 8/6/2026 respectively. And it is submitted by the learned counsel that so far they have already spent 81 days and 78 days respectively in under trial detention. Drawing attention to the order dated 7/8/2026 passed by the coordinate bench of this court in BA 2140 of 2026. The learned counsel submits that the the bail applicant in that case being Bhaskar Sinha was also forwarded, Bhaskar Sinha, he was named in FIR, I guess, no? Bhaskar
No,
Sinha.
no, Your
Is
Honor. Something.
Bhaskar Sinha is similarly placed as the present petitioners. And he was also arrested on 5/6/2026 and forwarded along with petitioner number 1. It is submitted that the coordinate bench was pleased to grant bail to the said petitioner, Bhaskar Sinha, with conditions. Nevertheless, call for the case diary from the concerned police station. Upon perusing the said order, I find the observation of the court that the investigation has substantially progressed. Full stop. In the said situation, considering the length of detention and the progress of investigation indicated by the learned court, I'm inclined to put on hold the under trial detention till the bail petition is adjudicated. Accordingly, in the interim, the petitioners are allowed to go on bail of rupees 30,000, same conditions. But let them go on bail interim. The call for the case diary to us in the meantime. List on
On my lord, 14th of September.
14 September.
Possibly.
Yeah.
483 application lordship, petitioner behind the bar on that 20 days lordship, as
Narayan.
on 5/8 lordship. FI allegation under section 108 of BNS lordship.
Bihari Kaur.
FR is
Meeting
page
secretary.
8 lordship. Here is the incident, disease commits suicide on 26/7/2026 lordship, and FR was raised or laws on 8/1/2026 lordship.
CD will be necessary. Call for this.
Yes.
So, Mr. Islam, right?
Islam.
B Islam Learned Council will be
Short date may be given.
call for the, we'll try and call for the case diary of Narayanpur PS case number 35 of 26. So petitioner was arrested on 5/8/2026. Yep,
39.
39.
Possibly.
May it please your lordship. Lordship, this is the second time bail application, lordship.
Never
Today
mind.
170 days in jail custody, lordship. May I take you the lordship, the FIR that is on page 17, lordship. That petitioner's wife committed suicide, lordship. And the brother has lost this info, FIR, lordship. The brother staying at Gauhati, lordship, and the incident happened at Botpeta Road, lordship. Now FIR, lordship will find on page 17, lordship.
Hmm.
After that, lordship, no specific instigation, lordship. After that, lordship, he was arrested. Forwarding report, lordship, will find on page 21, lordship.
2 months have elapsed since last rejection.
Yes,
Right?
lordship.
Investigation might be completed also.
No, lordship, only to that order, lordship, I'll take you the lower court order that is on page 9, lordship. Sorry, annexure 9, page 51, lordship. Till that, lordship, the informant is not turned up. Several data has been given.
So it's at the stage of trial.
Yes,
Also.
charge already framed.
Hmm.
So considering the length and lordship, no specific allegation, lordship, I have annexed the
Witnesses
lordship
are present,
161 statement of the other victim, independent witness, lordship. They have not implicated anything against this petitioner, lordship. Lordship has earlier occasion, lordship has perused the LCR, lordship probably remember that, lordship. Since lordship, they have not,
How many witnesses have been examined? so far?
till that, lordship,
I think
total
four.
out of 15, 5 witnesses has been examined, lordship. The
Okay.
informant is not turned up, lordship. The rejection order, lordship, will find on page
Okay.
51.
Mhm.
161 statement, lordship, I have annexed from
As going by this order, Mr. Bhattakur, 4 witnesses, according to you, 5 witnesses.
Five,
Okay.
Lordship.
But for the order itself reflects the 4 witnesses.
Your
Perhaps
Lordship,
we can consider a bail now.
yes, page 51, when the last, that on the other hand, the learned PP has objected so and so,
Informant not yet
sorry,
examined.
informant of the
Yes,
case.
he has given several
He
opportunities.
has not turned up.
Yes.
probably.
Let me arrange my defense, Lordship. Already, Lordship,
Can-
170 days.
Let him go on bail at this stage. No need to call anything. CD, we have case record, we have already seen. But would you like me to record your objection on the informant?
Yes, yes, Your Lordship, considering that. one-
I got ordered by para 2 and para 2, 3, 4. Full stop. This is a subsequent bail petition, and the earlier bail petition was rejected on 25/6/2026 in BA 1508 of 2026. Stop. At the time of the previous rejection, next para, the case was poised for commencement of prosecution evidence after framing of charge. Stop. In the meantime, approximately 2 months have elapsed. And in this context, the learned counsel, Mr. Chaudhary, has drawn attention to order dated 12/8/26 passed by the learned trial court, from which it is revealed that PW4 has also been examined. However, the learned counsel submits that as per his information, 5 witnesses have been examined so far, and though dates have been fixed for the informant, but he has not turned up so far. Full stop. The learned additional PP opposes the bail at this stage as other witnesses have not yet been examined, including the informant. Mr. Chaudhary, the learned counsel submits that there are 14 witnesses. How many? 14?
15, Lordship.
15 witnesses in the list, listed in the charge. Next paragraph. Considering the length of detention and the progress of trial, I am of the considered view that the petitioner should be allowed to go on bail at this stage. In such view of the matter, he is allowed to go on 50,000 with 1 security. Subject. Did he do? Current trial court.
In
Subject to the
connection with
condition.
present case.
Session judge.
Session Judge Borpata.
Borpeta. She is in Borpeta now.
In session case 45 public 2020.
Yeah. Subject to the conditions. Shall be available for the remaining trial, not hamper or temper, shall not cause any harassment, harm or upon witnesses or the informant side. Informant/victim side. Informant side. Violation will
Highly obliged, Lordship. Obliged, Lordship.
Number 5.
Yeah, please. The pre-arrest bail applications offense, Lordship, housebreaking, Lordship, robbery and rape. Lordship, I am finally see Lordship, page 16, vernacular portion. Lordship. That
diary will be necessary, perhaps. Isn't it?
this FIR has been filed after 4 months of the date of occurrence and name of the petitioner has
That
not
is
been mentioned.
peculiar.
Name of the petitioner has not mentioned, Lordship.
No, that is peculiar. The robbery, dacoity, and after 4 months.
4 months, kindly see page 16. My name is not implicated, not a specific
Anyway,
allegation,
so-
nothing else.
Then see
Page
the
15.
forwarding report.
No, Lordship, this is the anticipatory bail application, pre-arrest.
We have to call for the scan record.
CD may-
Scan or CD?
It is Lordship.
Charge sheet.
Charge sheet, the case which has been filed
Yes,
against
the
the
charge sheet submitted.
family members of the petitioner, informant, against which charge sheet have been filed, Lordship. First case was filed by
Oh,
the
that's-
family.
okay, then I have to understand. Just a minute.
Can TCR may be called.
The FIR in which you are seeking bail, that is at page 21,
Page
16.
16. So the case which has been charge sheeted, that is against the family members of the informant. That was filed earlier. That's why I have referred those FIR and charge sheet. Page 16 may be seen, Lordship.
I am on 16 only. Oh, that's a robbery as well as rape,
Yes.
causing injuries and then fled.
This allegation against the FIR named accused person. I am Sultan Akhiruজ্জামান. My name has not been mentioned in the FIR.
There is a clue here actually that the allegation, I am reading from that order, that if she lodges any complaint, they would make some recorded video go viral. This has become a very big. This case is under investigation.
Yes.
Mr. Borthaku? Yes. All for the case diary will be necessary.
My lord, then CD may be called for.
Yes, that will be necessary.
Interim maybe, sir.
No,
No, my lord,
I'm
this-
sorry, that will not be possible because of the nature of the case. And there are two serious allegations. Mr. Sarkar, learned counsel for the petitioner. Call for the case diary of Gulokganj space case number 165 of 26 under so and so. But you can try an early date.
Yes, my lord. On
So I am paying for interim lawsuit.
Interim will not be possible, I'm sorry, I mean, because of the two serious allegations.
7th or 8th of.
Robbery as well as rape
Yes,
and viral. and
yes.
That is why. On the face of it, we have to go.
On
Now,
8th
let us see the materials.
On 8th of September, 8th.
8th of September. If it's okay for you, no, otherwise next week you try.
Then on 3rd of September.
It's a truncated week, next 3rd of September.
No, sir. It may be 7th, Lord.
7th.
7th.
No, it is an anticipatory bail application matter. Allegation is of attempt to theft, not theft, but attempt to theft of a
Attempt
cattle.
to theft.
Yes, page number 29, FIR. The allegation is that my lord, some unknown miscreants, my lord, tried to commit theft of a cattle from the
Okay.
house of the informant, my lord, in a private vehicle
Mhm.
at 29.
You want to read? Or read the translated one?
Honman, I'll
I
read
can,
the vernacular.
I can quickly go through this thing also. Due respect. If you want to read, you can read.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা 28/2/26 তাৰিখে ৰাতিপুৱা অনুমান 4 মান বজাত কোনো অচিনাক্ত দুৰ্বৃত্তই মোৰ গোহালিৰ পৰা বলদ গৰু এটা চুৰি কৰিবলৈ চেষ্টা কৰে। মই সাৰ পাই দেখা পাওঁ যে পদকীয়াগণে এখন বগা ৰঙৰ চাৰিচকীয়া বাহনত আহি গৰু চুৰি কৰিবলৈ চেষ্টা কৰে। মই চিঞৰ বাখৰ কৰাত পদকীয়াসকলে উক্ত বাহনখন লৈ বাছবাৰীৰ দিশে পলাই যায়। ওচৰ চুবুৰীয়াসকলৰ লগত উক্ত বাহনখন পিছা লওঁতে কিছু দূৰ গৈ বাহনখন ৰাস্তাৰ কাষত গছ এডালত খুন্দা মাৰে। ফলত উক্ত বাহনখনৰ বহুত ক্ষতিসাধন হয়। ৰাতিৰ আন্ধাৰৰ সুযোগ লৈ পদকীয়াসকলে গাড়ী এৰি পলাই যায়। উক্ত গাড়ীখনত গৰু চুৰি কাৰ্যত ব্যৱহৃত হোৱা সামগ্ৰী যেনে প্লাষ্টিক, ৰছী, বিচনা, চাদৰ আদি উদ্ধাৰ হয়। ইয়াৰ পূৰ্বেও 28/2/26 তাৰিখে মোৰ এটা বলদ গৰু চুৰি কৰি লৈ যায়। গতিকে মহোদয়ৰ ওচৰত প্ৰাৰ্থনা জনাওঁ যে উক্ত পদকীয়াজনক কৰায়ত্ব কৰি বিহিত ব্যৱস্থা লোৱাৰ বাবে প্ৰাৰ্থনা জনালো। So this is the FIR, my lord, registered under 30535 BNS, my lord. Now, how the petitioner comes into the picture is this, my lord. The petitioner, my lord, entered into an agreement. Lordship will kindly have a look at page number 17. This is the actual owner, Sakir Hussain, my lord. He is the owner of the vehicle, my lord. And, my lord, the petitioner entered into an agreement for purchase with this person, my lord. But due to, my lord, financial problem, my lord, that did not, my lord, finalize, my lord. And, my lord, the car, my lord, is yet to be transferred in the name of the present petitioner, my lord. But, my lord, since, my lord, this owner is the, my lord, this Sakir Hussain is the registered owner. So when, my lord, police approach him, my lord, he is trying to shift the blame upon to the present petitioner, my lord, just because of the present agreement. But the actual thing is that, my lord,
Not yet transferred.
not yet, but the name still stands in this car still stands the name of the Sakir Hussain, my lord.
He'll record his statement.
Well, look, this is his submission and regarding that agreement, genuineness of that agreement.
He may be involved, so we don't know. At this stage, but anyway, let him
Earlier also
get a
same
chance.
incident occurred on 24 to 26 May.
Actually, this kind of offenses, ideally, police should conduct it just from the point of view of investigation, TIP. But unless it is something more serious, they don't take that trouble. Because otherwise, unknown persons, that's the best way of identification. Has thus learned counsel for the petitioner. Anything else from your side? And P. Borthakur, full stop. Invoking 482 BNSS. The petitioner is seeking anticipatory bail in connection with Kazigaon PS case number 7 of 2026 under so and so section. The gist of the allegations in the FIR is that on 28/2/2026, in the early hours of the morning, some unknown miscreants in a vehicle number AS 17G8576 tried to steal cows, and upon raising hue and cry, they fled away and subsequently hit a tree, roadside tree, after traveling some distance. As revealed above, no persons are named in the FIR. Mr. Das, learned counsel, drawing attention to the relevant document, transport document in this regard, submits that the owner of the said vehicle mentioned in the FIR is one Sakir Hussain, and that the present petitioner had made an agreement.
Is Sakir Hussain, madam.
The present petitioner, Diwal Hussain, no? Delwar Hussain, had made an agreement with the said Sakir Hussain for purchase of the vehicle. But it has not yet been transferred due to his financial difficulties. Full stop. It is submitted that when the vehicle got implicated, the owner is trying to rope in the present petitioner. And in this backdrop, he is seeking protection from this court. Call for the case diary. However, in the interim, in the event of arrest, 25,000 with funds security to the satisfaction of the arresting authority and subject to the conditions, will cooperate in investigation. Can he record his statement? He will appear. He will cooperate with investigation. He shall appear before the IO, making himself available for examination. Shall not hamper or tamper with evidence. List on
15th of September.
okay. 15th of September.
31.
Wait, please, madam.
Bulogons.
FIR is at page number 19, my lord. Here the case is that, my lord, around 37 numbers of cattle were detained in a 6-wheeler truck, my lord. And on the day itself, my lord, the driver and the co-driver were arrested. And subsequently, my lord, they were also released on bail. Now, these present petitioners are the owners of the 37 numbers of cattle at page number 19, my lord.
This is the Azahar.
Azahar, madam. May I read, madam?
Okay.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে ছাগলী আৰক্ষী চকীৰ দৈনিক সাধাৰণ পঞ্জী 10 নম্বৰ চোৱেনচো মৰ্মে আজি ৰাতিপুৱা 6:10 মান বজাত মই ASI লগত UBC আৰু আৰক্ষী চকী সন্মুখত থকা 17 নম্বৰ ৰাষ্ট্ৰীয় ঘাইপথত নাকা চেকিং পইণ্টত যান বাহন তালাচী কৰ্তব্য কৰি থকা সময়ত ৰঙা ৰঙৰ 6-চকীয়া আইচাৰ ট্ৰাক গাড়ী এখন পশ্চিমবংগৰ ফালৰ পৰা গৌৰীপুৰ অভিমুখে আহি থকা অৱস্থাত নাকা চেকিং পাৰ্টিয়ে সংকেত দি ৰখোৱা হয়। সোধপোছ কৰাত গাড়ীখনত পোৱা চালক মফিজুল আলী আৰু মজিদুল ইছলাম প্ৰথম গাড়ীখনত আম ভৰ্তি থকা বুলি কয় যদিও তেওঁলোকৰ আচৰণত সন্দেহ হোৱা উক্ত নম্বৰৰ আইচাৰ গাড়ীখনৰ ট্ৰিপল খুলি চোৱাত গাড়ীখনৰ লুৰ ক্লামেৰে অতিৰিক্ত কেবিন বনোৱা দেখা পোৱা যায়। লুৰ ক্লামেৰে বনোৱা চাঙৰ ওপৰত অংশত গেলা পচা আম ভৰ্তি মুঠ 55টা কাৰ্টন আৰু তলৰ অংশত ইয়াৰটেগবিহীন 37টা গৰু লুকাই অনা পৰিলক্ষিত হয়। প্ৰতিটো গৰুৰ মুখত আৰু ভৰিকেইটা ৰছীৰে অতি টানকৈ বান্ধি কেইটা লৰচৰ কৰিব নোৱাৰা এখন পশু কঢ়িয়া অনুপযোগী মালবাহী ট্ৰাক গাড়ীত 37টা গৰু অতি অমানৱীয় অত্যাচাৰিতভাৱে ভৰ্তি কৰি আনিছে। গাড়ীদ্বয়ৰ চালকৰ পৰা গৰুকেইটা নথি পত্ৰ বিচাৰ তেওঁলোকে গাড়ীখনত ভৰ্তি অনা গৰুকেইটাৰ কোনো বৈধ নথি পত্ৰ দেখুৱাব নোৱাৰে আৰু নাই বুলি কয়। তেওঁলোকে উক্ত গৰুকেইটা পশ্চিমবংগৰ ফালাকাটা নামৰ ঠাইৰ পৰা অসমৰ বঙাইগাঁও জিলা অভয়পুৰীত খালী কৰাৰ উদ্দেশ্যে লৈ আহিছিল বুলি জনায়। সন্দেহ হয় যে গাড়ীখনৰ চালক আৰু তেওঁৰ সহযোগী লগত গাড়ীখনৰ গৰাকীয়ে মিলি কোনোবা অজ্ঞাত গৰু সৰবৰাহকাৰী জড়িত হৈ পশ্চিমবংগৰ কোনো অজ্ঞাত ঠাইৰ পৰা উক্ত ট্ৰাকখনত মুঠ 37টা গৰু অতি অমানৱীয় অত্যাচাৰিতভাৱে ভৰ্তি কৰি চুবুৰীয়া ৰাষ্ট্ৰ বাংলাদেশলৈ পঠোৱাৰ বাবে অবৈধ তথ্য চোৰাংভাৱে অসমলৈ সৰবৰাহ কৰাৰ ষড়যন্ত্ৰ কৰিছিলে। ঘটনাৰ বিষয়ে চকীৰ মহোদয়ক অৱগত কৰা তেখেতৰ নিৰ্দেশ মৰ্মে সাক্ষীৰ সাক্ষাতত মুঠ 37টা গৰু লগতে গাড়ীখন আৰু উক্ত গাড়ীত অতিৰিক্ত কেবিন বনোৱা ব্যৱহাৰ কৰা লুৰ ক্লামেৰে মুঠ 11টা আৰু 55টা কাৰ্টন জব্দ কৰা হয়। গৰুকেইটা ভেটেনাৰী অফিচৰ জৰিয়তে ডাক্তৰী পৰীক্ষা কৰা হয় আৰু গৰুকেইটা কৰজালি চৰকাৰী খোৱাৰত ৰখাৰ ব্যৱস্থা কৰা হয়। Now, Lordship will see.
As per the FIR, the cows were brought in a very cruel manner.
Yes, prima facie my cruelty is there.
Page number
7
21.
numbers of
Yes.
21, my lord.
Hmm.
The driver and the co-driver, Mufizul and Majidul Islam, they were released on the very first day, my lord. They were granted bail.
The owners are the main accused. Until 30, only 6 my lord, kettles permitted.
Now, my
Well,
lord, the present petitioners, my lord, are the owners of the kettle. And
Kettles have been recovered.
yes, lordship will kindly have a look at page number 33, my lord. The present petitioners, my lord, they filed a prayer for Jimma before the learned court below, my lord.
Just a minute, no, it's a very long bail order. Anyway, page
33, my lord.
33. Jimma was refused,
Jimma was allowed, my lord.
allowed.
Allowed. Now, lordship will kindly have a look at 35, my lord. The Jimma petitioners, my lord, are directed to appear before the IO, and the IO in turn is directed to give the interim Jimma of the aforesaid cattle to the Jimma petitioners only after proper verification and after obtaining a Jimma bond of double the market value of the said seized cattle from the Jimma petitioners with the conditions incorporated in the said bond, that they will produce the cattle before the IO or the court as and when asked to in connection with this case. So, my lord,
All the petitioners here
yes, yes, my lord. Now, the thing is that because of the omnibus allegations in the FIR, my lord, they are having some apprehension, my lord. So they want to appear before the IO as per the direction of this honorable court to submit the documents, my lord, and to collect the cattle.
But they were, anyway,
The Jimma petition was filed by the Jimma petitioner is represented. So on behalf of them, my lord,
Jimma was also given, so I think we'll have
Yeah.
to give them a chance to,
Yes,
but
well, last
the
line, my lord,
cattle were carried in a very inhuman manner,
27 numbers of.
very
cattles
inhuman,
in a Very cruel manner.
cruelty of
that will
animals
be
act.
on the, my lord, driver and the
That
co-driver,
will
my lord,
be
who has carried. But
PCA,
these are the genuine owners of the cattle, my lord.
PCA and, also the Cattle Preservation Act. Anyway,
And even there is specific bar under the cattle
there is,
preservation act for.
anyway, but let them record, but that aspect is there. Carried in a very, they are also living beings.
But
Yeah.
regarding that Jimma, those only to the persons who were represented the accused persons, my lord. Only
It was the last time.
All the petitioners were also Jimma petitioners.
Yes, yes, my lord, four.
S. Das learned counsel for the petitioner and P. Potter, 482, no, Gologon space 177 of 26 under so and so section. The case arose out of an FIR dated 31/7/2026, lodged by a police official from the Gulagons police station, from the Chagalia outpost under Gulagons PS, with the allegations that on that day, there was a Naka checking whereupon a truck bearing registration number, when a big truck bearing registration number AS01UC 2045 was coming from the side of West Bengal, and upon asking, the drivers stated about carrying mangoes. Full stop. It is further alleged that upon more thorough checking, 37 hours of cattle were found being carried in cruel conditions, in cruel and inhuman conditions. Full stop. The driver Mofizul Ali and co-driver Mazidul Islam were apprehended. Full stop. Along with the truck and cattle. Next paragraph. Mr. Das learned counsel submits that the present petitioners are the owners of the cattle, and they wish to appear before the IO along with all documents. They submitted that they had approached the learned court below, seeking interim custody of the cattle, which was also allowed by order dated 18/8/2026, passed by the learned SDGM S. Dhubri.
May I leave, man?
Huh?
May I take a leave, man?
Learned counsel also submits that the arrested driver and arrested drivers of the vehicle were subsequently granted bail by the said learned court below on 1/8/2026. In the aforesaid facts and circumstances, the petitioners are seeking anticipatory bail. The learned additional PP opposing the bail submits that the cattle were being carried in violation of the Prevention of Animal Cruelty Act as well as the Assam Cattle Preservation Act. And the numbers carried were much beyond the permissible level. So, next paragraph. Call for the case diary from the concerned police station. However, in view of the other attendant facts and circumstances as narrated above, it is directed that in the event of arrest of the petitioners in the interim, liquid about 30,000 each, with a surety of the like amount each, to the satisfaction of the arresting authority and subject to the condition that they shall cooperate with the investigation, appear before the IO, making themselves available for examination. They shall not violate any, they shall not commit any illegal activities or offenses, shall not hamper or tamper with it. List on, it will be on 14th.
14th, yes.
Bail hearing delay, এখন করতে
Correct, your lordship. That's a regular bail application, my lord. The charge sheeted case, my lord. Well, I was granted interim bail, my lord, on medical ground, my lord, on 22/6/26, my lord. Well, I want a week's time, my lord, to file the medical report and the operation which has been done upon me. Lordship, may kindly fix it on the next week, my lord.
Scan copies. Mr. NJ Dr. Learned Counsel for the petitioner, DP Goswami, D. Parasar. You are appearing as amicus for the informant. The petitioner was granted interim bail on by the order dated 22/6/2026 on medical grounds and imposed with some conditions. The doctor submits that the petitioner petitioner is seeking a week's time to file his medical documents. The prayer is allowed. You will file through an affidavit.
Can it be on 7th of September?
The prayer is allowed. List the matter on 7th. In the meantime, the additional documents can be, the medical documents can be brought on record. Scan TCR is available.
আপিল করে দিবেন।
May I please your lordship? Lordship, this is a 483 application, my lordship. My lordship, 183 days as on
93 days.
my lord.
Lordship, in this matter, Ms. P. Sharma was appointed as amicus curiae. She is on Lexing Court number 1. Maybe taken up after some time, Lordship.
Should be. No problem. After some time.
May it be pleases you, lordship. Here, your lordship, this is application filed on under 483, your lordship, BNSS. And here, arrested person is on dated 10/4/2024. And the length of detention, your lordship, is more than 2 years up. So, your lordship, I'm praying on the length of detention for timing, your lordship. And moreover, your lordship, paragraph 6, page 5 of my bail application. I'd like to read it, your lordship, paragraph 6. That the petitioner begs to state that the victim X came to their house along with her friends to get some palm berry, that is teriju, to eat, as accused petitioner does have one planted tree of some palm berry, that is teriju. She asked the accused petitioner to have some dates after giving permission by him. She has climbed the tree palm berry, that is teriju, but very unfortunately she fell from that tree and got hurt, while accused petitioner bring her to his house and helping to clean the teared up skin of the victim. But unfortunately, he was framed as accused and projected with a false registered case. Although the accused petitioner was not alone at the time, other family peoples of the accused petitioner were present when the girl fell down from the palmberry, that is terejo tree. On the basis of a minor girl narrated the story, this case was registered with ill motive just to harm the accused petitioner reputation. And they are niece, your lordship. They are from same family members, your lordship. So, your lordship, out of ill motives, your lordship, his reputation was harmed. And moreover, your lordship, in the medical report also, your lordship, nothing has been found.
Trial must be, must have progressed.
Going on, your lordship, I would like to draw your attention to page 38, annexure 3. That is medical report, your lordship.
Page 38.
38,
Ah,
annexure
yeah,
3.
I'm on that.
Yes, your lordship. And here, your lordship, opinion owing to external injury. Thereafter, your lordship, opinion was
Yes.
given, your lordship. And here I would like to press this, your lordship. No spermatozoa was detected in vaginal, your lordship. So it is a clear case of, your lordship, to framing that accused, your lordship. And your lordship, trial was
Anyway,
going on, your
so,
lordship, until date, your
If
lordship.
the victim, what is the stage of victim has been examined?
He has been examined, Lordship, in here, Lordship, here, charge sheet submitted on H6/26.
Okay.
And
Yes.
charge framed on
Oh,
10/9/20.
there was delay in filing the charge sheet.
Yes,
Yes.
Considerable delay in filing the charge sheet.
charge framed on 10/9/24. There are 15 PWs are there. Out of 15, 10 PWs already examined.
Already examined.
Yes.
Okay.
And Lordship, victim along with the friends of the victim who is the eyewitness of there, they have already examined and fully implicated. 12 years minor child was sexually harassed and assaulted and committed rape on her, Lordship. A 47 years man, Lordship. And in the medical report also, I have flag mark there. The medical incident took place on 8/4/24 and medical was done on 9/4/24. But redness present in the,
That I've seen.
yes, Lordship. Yes. And tenderness present also, Lordship, of left knee of the eye. I have flag marked the deposition of the victims also.
Length of the
The
detention.
victim was examined as PW. Right?
PW2.
PW2. Charge sheet already, your lordship, annexed it, your
PW
lordship, as annexure 1A, that is on page 19.
Implications, but implication is there.
Yes, full
Implication-
implications are there.
Implications are there, but we can.
Trial is going on consistently in a regular manner, Lordship, and out of 50.
Your lordship, I have annexed it, your lordship. There are several occasions, your lordship, they have not turned it, your lordship. Your lordship, page 36. Page 36 dated on 25/2026 of my petition, your lordship. PWs are absent today. There also, your lordship, PWs has absent.
And next date was
And your-
12/8/26.
He was very much there, your lordship, and already prime, your lordship, evidence were already taken, your lordship. So, your lordship, pertaining
Okay,
to
but
the
if we,
length of detention, I'm,
length of detention is in his favor,
yes.
no doubt. But implications are there So if he absconds, then the trial will be
Your lordship,
installed.
your lordship.
But we cannot
interim-
assume that he will
Yes,
abscond.
your
That is
lordship.
also true.
Any strict, your lordship.
Oh, here, there are only two concerns, abscondence and any harm to the victim.
Victims, and because
Those are
the
the
family,
only
he's
concerns.
also a family member of the victims. He's a
And
ma-
the allegations are also very serious.
It is,
Any strict conditions may be given, your
how
lordship.
many witnesses are there?
15 PW, sir.
15. 5 already examined, 10 examined. Then perhaps we better to wait by the length of detention. Well, make an observation that the trial will be completed expeditious
Yes, yes.
remaining, so that otherwise there's some,
We're concerning about the mental
Your
agony of the
lordship,
child.
any strict.
otherwise, no, I
Conditions
understand,
to be
madam.
given, your lordship. The petitioner is behind jail, your
That's
lordship,
true,
from
but
the
then-
arrested date. No other applications, bail application has been, your lordship.
Yes, that's why he's seeking legal aid.
It
Uh,
10/4/2024 onwards, he
Lord
was
Mr.
behind the jail.
Mrs. P. Das, learned legal aid counsel appearing for the petitioner. DP Goswami, learned additional PP, and you're for the informant.
Yes, madam.
Informant. You also amicus curiae, learning amicus curiae appearing for the DECA appearing for the respond number 2 informant. Full stop. Invoking 483 BNSS, the petitioner herein is seeking regular bail in connection with North Lakhimpur PS case number 88 of 2024, which after completion of investigation resulted in a charge sheet and registration of special POCSO case number 68 of 24. Full stop. The case is presently at the stage of trial before the learned special judge POCSO, North Lakhimpur. Full stop. Ms. Das, learned legal aid counsel points out that the petitioner has been in under trial detention for more than 2 years since his arrest on 10/4/2024. And that in the meantime, the trial has also progressed, including the examination of the victim. Full stop. The learned counsel has also taken the court to the medical report and indicated absence of spermatozoa stated therein. Full stop. Next paragraph. On the other hand, the scanned TCR is available, and I perused the relevant portions thereof, including the deposition of the alleged victim girl / prosecutrix, who stated to be aged around 12 years
12 years.
at the time of the alleged incident. Full stop. The learned Mr. Goswami, the learned additional PP, submits and contents that out of 15 witnesses, 10 witnesses have already been examined, and there are significant implications against the petitioner, including from the testimony of the prosecutrix. It is submitted that bail considering it is submitted that the petitioner is also family member of the victim, and that in view of all the circumstances, a bail may not be considered. Mr. Dekal, the learned amicus, supporting the contentions of the prosecution, further submits that the allegations are quite serious. Next paragraph. I've given my consideration to the matter. The length of detention is undoubtedly on the higher side. Under trial detention is undoubtedly on the higher side. I have perused the depositions of some of the witnesses available in the scan record, including that of the victim. Full stop. Only 5 witnesses remain to be examined. Full stop. The victim is stated to be aged only 12 years. Full stop. Considering the various aspects of the matter, I am of the considered view that perhaps it would be prudent not to grant bail at this advanced stage of the trial. Full stop. In such view of the matter, the bail petition stands rejected. Full stop. Whatever anything stated here is only for the purpose of the bail adjudication and should not be taken as expressing any opinion on the merits of the case undergoing trial. Full stop. The court also records its appreciation for the efforts put in by the learned legal aid counsel and the learned amicus.
Deeply appreciated.
Lordship, I have just filed the bail application. It is got
Clear.
fixed to me.
Corrected bail application.
They have filed objection, my lord, to my bail application.
Objection.
Maybe, my lord, day after tomorrow, my lord, along with the objection, my lord.
Your good name, please.
Armando, Lordship.
R. Mandal. Mr. Mandal, R. Mandal, learned counsel for the respond number 2, informant. Right? Informant submits that a bail objection has been filed only today and it is not yet come into the record. Full stop. Mr. Bora fairly submits that the matter may be allowed to come up on Thursday. Scan record is available. List the matter on day after tomorrow.
14 not 13. As per office note dated 21/8/26, service report is awaited.
Service report is
Service of notice.
My lordship, my brother may take instructions with regard to service of.
You have taken steps. Yes.
Lordship.
I have taken them.
Kindly take the instructions. As per office note dated 21/8/26, service report is awaited with regard to R2. Scan record is available. The prosecution shall take instructions regarding such service. List on. Work it out.
Which is 3rd of September.
3rd of
3rd of September.
Oblige, my lordship. Please, your lordship.
I have request from my senior to pass over the matter for the time being. He is in court number 1.
Okay, after some time.
Oblige.
Please, your lordship. The charge sheeted matter, lordship, quantity involved, lordship, that 21B, lordship. And already on 115 days in custody, lordship.
Yes.
And there were 2 accused, lordship. One has been already been enlarged on bail prior to charge it. And now, lordship, 115 days. Further custody detention, lordship, they.
How many witnesses examined?
No, lordship. 8 witnesses are there, lordship.
Not started.
No.
Not started.
For a local person, lordship, further custodial detention might have 115 days.
Charge is
lordship.
premium.
And quantity recovered, lordship, 5.26 gram. lordship. If you are, lordship, any condition, lordship. there. Quantity is, lordship, 5.26 gram.
Third, Mr. Invoking 483 VNSS, the petitioner is seeking regular bail in connection with the special NDPS case number 39 of 26 under section 21B/29 of the NDPS Act, which had arisen out of Tarabari PS case number 19 of 2026. The case is stated to be pending for trial before the learned special judge Porpeta pursuant to framing of charges under section 21B/29 of the NDPS Act. Full stop. The petitioner was arrested on. When was he arrested?
Arrested on, lordship,
18/4.
2/5.
2/5/2026 during investigation. And it is submitted that he has spent approximately 100
115 days, 115.
115 days in under trial detention. Full stop. 8 witnesses are listed in the charge sheet, and so far the examination of the prosecution witnesses has not started. It is submitted by the learned counsel that the sole co-accused, Ali Hussain, was granted bail.
Not television, Lordship. It was Jeherul Mia, Lordship, that order.
Oh yeah, the sole co-accused, Jeherul Mia, was granted
Page 24, Annex 5.
was granted bail by the learned trial court by order dated
18/6/2026.
18/6
24.
18/6/2026. Full stop. 18/6/2026. Full stop. I have perused the certified copies of the documents annexed with the bail petition. Full stop. Next paragraph. The learned additional PP, Mr. Goswami, opposing the bail, submits that prosecution evidence has not yet commenced. Next paragraph. I have given consideration to the matter, full stop. Keeping in mind the length of detention, comma, the stage of the case, and also the aspect of parity, comma, I am of the considered view that this accused can also be granted bail at this stage. Accordingly, 50,000 with one security to the satisfaction of the learned session judge Borpeta, and subject to the condition that he shall be available for trial, shall not hamper or tamper with evidence, shall not commit any offences or illegal activities. Violation will entail bail cancellation. Disposed.
Much obliged, Your Lordship. Much obliged.
May please, your lordship. My lord, it's a regular bail application. The lordship will find the FIR is 20. My lord,
Page 20.
NDPS case, my lord, the facts behind the case is that, my lord, the vehicle was coming from Manipur to Assam, my lord, Gauhati, and via Shillong. While in the border, the vehicle was in border, the owner of the vehicle has picked up this present accused petitioner and taken to the border and boarded into the vehicle to assist the driver. That was the stage, my lord, and so he does not know what is about the my lord, motive of this vehicle and what materials are loaded in the vehicle. He was not aware. Now the facts, my lord, the case is that the person is in custody for more than a period 1 year, my lord, and till date no witness has been examined. Although, my lord, the quantity has been shown commercial quantity, but there is, my lord, contradiction as per this charge sheet. Once it is said that 295 grams, and another there is a statement that it is 285 grams. So there is a contradiction. And another point is, my lord, the materials was found in below the seat of the driver, my lord. So they were not in conscious position, and and the procedure of the, my lord, the chaser. The chaser was not conducted in presence of the executive magistrate or any other gazetted officer, my lord, and therefore the the provisions of the
25.
TARS and chaser is not followed in proper way, and the materials after recovery, it was sampled, and the investigating authority sent to the testing, my lord, laboratory, and that took more than a 2 months period. As per the
It takes time.
As per the provisions under government standing order, rule 14, my lord, I have annexed in my writ petition and in my petition, my lord, lordship, you may kindly have a look at
Just a minute.
a page starts from page 61. The relevant provision 14 is at page 63. This goes to show that it should not be more than 30 days.
Oh, that is there, but it takes time. That is the problem because of the
My lord.
overload. Anyway, this original record has come.
Yes, record this. Scan copy of PCR. ma'am.
Scan copy or
Scan copy.
original? Looks like original.
I have flag
My
mark
lord,
of
no,
those.
more than year has been elapsed, my lord.
Let us see.
No witness has been examined as on today, my lord.
Yeah, trial has not started.
The trial, my lord, date, till now, my lord, no witnesses examined, my lord.
My lord, the order by which our bail petition has been rejected by the court below, this goes to show that there is no PP. Lordship will find it page 78, the bail reject
Which in
order.
which court?
My lord, NDBS case, NDBS, my lord, special judge NDBS Gauhati.
In Gauhati. How come there is?
There is no PP, my lord. The bail petition before
be a
the
special
court below has been rejected for absence of the PP. Under that situation, my lord, it is a fit case to be considered, my lord, for allowing him to go on bail. And there has been some other violation. The notice was issued. The notice for arrest notice was issued, not in vernacular language. So section 47 has been violated. Then, my lord, 48 is also violated.
Has it been explained to him? He has been, the grounds of arrest has been explained to him.
Yes, yes.
Hmm?
Those are there,
Yes.
my lord. Those
It's in the-
counter, my lord, I have, in fact, my lord,
Is there?
flag marked earlier order dated of trial court, my lord. Those grounds were already rejected by the trial court by order dated, my lord, 5/8.
My lord,
Bail rejection order 28/7/26, 5/8/26, my lord. I have flag marked, my lord. And otherwise regarding from the possession of the present accused person along with one other, my lord, those contrabands were recovered, my lord. FSL also confirmed heroin. And proceedings are going on, but fault on the part of the prosecution for delaying the matter, my lord. Only 1 year, 2 months, my lord.
He was in the vehicle. Right?
Yes,
This
yes,
person was in the
yes.
vehicle.
Caesar list is there, page
I was
29 also
I was
from the
boarded
position
in
of
the
the
vehicle
present
in
petition.
Assam Meghalaya border.
From the position
to-
of the present petitioner along with other those, my lord, those contrabands were recovered.
Not as a driver. The vehicle was coming from
From the yes,
Manipur.
yes.
So
Those-
I don't know what is the purpose of moving coming from the vehicle.
Those-
The owner has boarded me into the vehicle.
Fact is that from the position of the accused person, those contrabands were recovered. And regarding he was a passenger, my lord, whatever, my lord, those things will come during trial only.
Quite the elaborate order. The bail rejection order is very elaborate.
Yes.
Though the PP was not assigned, but the court has gone into all the aspects. It's
My lord,
it's gone all in.
the court order goes to show that there is no PP.
No, that
And
that is
court,
an
court
your,
have
your
rejected
submission
only
is
on that ground.
no, not at all. That's an incorrect submission. Fairly elaborate order. All aspects have been discussed,
yes.
including PA Najib, including 37. All the aspects have been discussed. Tufan Singh, everything. That is not correct. It'll be foolish for a judge to reject only on the ground of not having PP. That's not the accused fault. Let me see the. Mr.
I
Bhatta,
was in the vehicle as a laborer, my lord.
it can happen
I'm not
sometimes,
regular
but it's very difficult to make out at this stage. You know, it's a matter of evidence. Yes, being at the wrong place at the wrong time can definitely get people into trouble. That's really bad luck if it's, you know,
My
but
lord,
it happens.
The
in life.
trial not commence, my lord, more than a year, my lord.
But
My lord,
37 I have to see.
some judgment in this regard. my lord.
37 I have to see because
My lord, Vasile.
when was he arrested?
My lord, on 4/6,
4/6 of
2025.
2025.
1 year, 2 months.
Wait to delay.
My lord,
Have you marked the Caesar witnesses?
Caesar witness,
No, I'm asking him.
No, my lord, I will have 2 months.
Just here. His name is, what is his name?
my name Rubiol Mia.
Hmm?
Rubiol Mia.
One person, right?
One person. my lord. 2 persons were arrested.
No, he's one of them.
Driver,
He's one of them.
another person. I am
Uh-huh.
I was
Rubiol.
boarded as a
Uh-huh. Uh-huh.
Trademark, my lord. His name as accused number 1.
Detection of. That's Vikas Rai. Only the tokas are there is
He is the
Rockview.
driver of the vehicle, driver.
I am
Just a
not the
minute.
driver, my lord.
Please mark the Caesar witnesses, huh? Whenever you get
Yes,
the
ma'am.
diary. Because it will
So
save
there
us
are
some, it
Caesar
will save us some time.
Yes.
I have not been able to locate so
My
far.
lord, I will.
I'll try once, then I'll give it
On
to
the
you.
CD, my lord. And in the search sheet dated, my lord, page 56, what is Caesar witnesses, their names are there, my lord.
No, I found the names of the Caesar witnesses.
One Vikas Rai,
No, I'm not mentioning the
One
name, but I found.
Pandit Sharma, my lord. And the present petitioner is the driver of the vehicle, my lord, and one Sanwar Hussain, he is the handyman.
Just mark it.
Yes, my lord, from the case,
There's another.
CD part, my lord. Caesar is-
It's here. It is here. Yes. 43. Heard, Mr. A. K.
My lord, I
Yes,
have to refer, my lord, to the judgment, my lord.
Yes, please.
On the point of, my lord, not examining witness for long detention. Another, my lord, the conscious position, the point of conscious position. And my lord, there was defect of
Actually, the
sampling.
reverse burden has to be discharged by you. Once it is found under the seat where the person was also present, the foundational, if that is proved, the foundational fact the prosecution has proved, then the burden shifts to the person. He has to show that he was not aware. Now, that is, with all respect, is a matter of trial. It's very difficult. We have to
My
know
lord, there is a
go by the
defect
prima
in the
facie
sampling
method.
also, but sampling was not properly done. My lord,
Najib,
without presence of
the court
agreement.
has, Najib is a, I always believe Najib is a great judgment, but we have still not determined, it's difficult to determine also, difficult to stipulate also that so much of under trial detention, if trial is not completed within so and so period, then the person will be entitled to bail invoking Article 21. If something like that is laid down, it will be very good. But so far it has not been laid down. It is not easy to lay down also because it will vary from facts to facts. Suppose 2 years, suppose something just for argument's sake. But it has not been laid. Some cases, because Najib has laid down a very important principle that what is the exact point at which the what will be the exact trigger point at which Article 21 will prevail over the statutory restrictions. There is a, I've forgotten the para number. There's a, because that sums up the law actually. That it says, the judgment says that way you can harmonize the statutory restrictions and the Article 21. Otherwise, for example, the statutory restrictions are also there. This was in the case of UAPA, but the same principles apply. 37 is even more rigorous than UAPA 43D. So the judgment says that if immediately Article 21 is brought into force, then the statutory restrictions will be defeated. So initially the statutory restrictions will be allowed to prevail. But if the trial is not completed after a certain time, then at a particular point 21 will come. But what is that point? So far we do not have guidance. It has been in some cases long detention has also not been held to be sufficient. Some cases have been. If it is laid down, it will be very good. But as I said, it's not easy to lay down a standard also. Just like that. It's a very beautiful, paragraph. Otherwise, everyone should get bail. Why not? Because of the statutory restrictions. Commercial quantity, whenever such statutory restrictions are in place, it means another thing, that you cannot delay trial. When person is not being granted bail due to some law restrictions, then trial should be expedited. That is the responsibility. It cannot be a situation that trial is also not progressing. Person is also in custody. That will be very unfair. But anyway, I will not waste your time on this particular paragraph. There's a very beautiful paragraph in Najib where this has been summed up.
I have given number of.
Summed up. This that length of detention and as well as this.
My lord, the wrong sampling and.
Yeah, Najib. Wrong sampling.
Undue, more times taking, my lord, for sending the samples and receiving the test report. My lord, these are the points, my lord. Spot sampling was not done in presence of an executive magistrate or a nearest magistrate, my lord, or gazetted officer. That was not done, my lord. And the Avtar Singh and Hori Singh case, my lord, there is a discussion about what is called conscious possession. I was boarded in Assam, Meghalaya border. My lord, driver was coming from Manipur to Gauhati. My
How many witnesses were there in the
My
charge?
lord, as per
Huh?
order 6 with me.
Only 6 witnesses. Should have completed by now anyway.
Driver, the present accused person is the driver of the vehicle. ma'am.
Can I dictate? Sit down, please. Mr. A.R. Sikdar, learned counsel for the petitioner, who has invoked section 483 BNSS, seeking regular bail in connection with special NDPS case number 308 of 25 under so-and-so section. The case had arisen out of Basisto PS case number 313 of 2025, which was registered based on an FIR dated 4/6/2025. The allegations, the allegations in a nutshell in the said FIR was that a confidential information was received by Basisto police about used consignment of heroin being transported in a 6-wheeler truck bearing registration number AS01LC1253, full stop. Accordingly, an operation was initiated and the vehicle was intercepted. The driver and the handyman were found inside, full stop. And in the presence of independent Caesar witnesses named in the FIR, the search was conducted, whereupon 22 soap boxes were found containing suspected heroin in different quantities. The total weight of the suspected heroin was found to be 295.46 grams. Full stop. It may be mentioned herein that quantity above 250 grams in case of heroin falls in the bracket of commercial quantity. Full stop. Both the driver and the handyman were apprehended, and the present petitioner Rabiul Mia is stated to be the driver. Full stop. After completion of investigation, charge sheet was submitted in the case, and the case is presently pending for trial before the learned trial court, court of the learned special judge NDPS Gauhati. The petitioner was arrested on 4/6/2025 and continues to be in under trial detention. Mr. Sikdar, learned counsel, apart from pointing out the length of detention, also submits that the order dated 28/7/2026 passed by the learned trial judge rejecting the bail is erroneous. Full stop. It is submitted that the petitioner was not at all in conscious possession of the alleged contraband, and full stop. From the record, the scan record is available, and therefrom I find that by order dated cannot read this order. No, I won't give. I find that the trial court was pleased to frame charges against both the accused persons under 21C, 25 and 29 of the NDPS Act. Also, Section 29C pertains to commercial quantity, wherein the rigors of Section 37 of the Act have to be tested to decide the question of bail. From the learned counsel has referred to the decision of Union of India versus K.A. Najib, 2021 3 SEC 713, to contend that long incarceration during trial should entitle the petitioner to bail. Full stop. The decision in Avtar Singh versus State of Punjab 2002 7 SEC 419 has been relied upon to contend that the petitioner was not in conscious possession. Full stop. Reference is also made to the decision in Arvind Dham versus Directorate of Enforcement regarding to buttress his submission regarding bail. This Arvind Dham 2026 INSC 12. Full stop. I perused the materials. No, I'm sorry. On the other hand, the learned additional PP proposing the bail submits that the materials implicate the accused persons and there's no infirmity in the decision of the trial judge in holding that the rigors of section 37 would prohibit grant of bail. I have perused the relevant materials and considered the submissions. Full stop. The informant has supported the allegations about seizure of the contraband from the truck upon search. Full stop. I've carefully perused the statements of the seizure witnesses who were purportedly witness to the search, and both of them have supported on identical lines about the conducting of the search in the truck, finding of soap boxes and the heroin therein. Full stop. Upon considering all the materials, including the seizure documents, I am unable to disagree with the opinion of the learned trial court that it cannot be said that there are no reasonable grounds to hold that the accused persons are not guilty. Full stop. To that extent, the statutory bar on grant of bail would prevail. Full stop. As far as the principle laid down in PA Najib is concerned.
My lord, I have one case law, my lord. I failed to collect it, my lord.
Okay, kindly send it across. Before signing, I'll look at it. I'll supplement my order.
Mohammed Muslim alias Hussein versus State, NCT Delhi of 2023.
Full stop.
Here in this case, my lord, the strict restriction of section 37 has been discussed. My lord.
Yeah.
That cannot be fatal to grant bail. Mohammed Muslim alias Hussein versus State,
I've heard about
NCT of Delhi, 2023.
What is the subject matter of this decision? Muslim.
My lord, here, my lord, the section 37, the
Of NDPS Act.
NDPS Act, my lord, the strict restriction of 37 do not fetter the grant of bail if there is prolonged incarceration and inordinate delay.
Constitutional provisions prevail over everything. Full stop. With regard to the principle laid down in Najib, it remains to be seen whether the trigger point has been reached, whereby the said constitutional principles under Article 21 would prevail over statutory restrictions like Section 37. In this regard, the reference to Muslim, I'll complete the rest after seeing that dish. No, I can also locate it, but if you find it, send it to me. Very difficult. 37 is even more difficult than UAP because UAP says prima facie grounds, reasonable grounds, prima facie grounds. But here it says that to reasonable grounds to say that he's not guilty. And after framing charge, how will you say that he's not guilty? It's very difficult. That means indirectly it is said that don't give bail, but at least speed up the trial. You can also take up that matter. I will make an observation. If necessary, mark you a copy.
The order passed by the trial court goes to show that there is no PP.
That's the fact. But that cannot be an excuse. Such an important court, special judge was sanctioned long time back. It was not functional. Finally, it is functional. Very good. But you can take up. You can also pursue that matter since you are a public prosecutor of the High Court. PP must be appointed immediately so that trials are not. Actually, these special courts of NDPS, in my opinion, they are meant for trial of commercial quantity, where people are not getting bail because of statutory. It's paid for that. Actually. Anyway, after Nana?
Number 18.
Here, as per the office notes, the service is not complete, and my lordship, I think the CD was called for and that is also not received.
Proceed.
Yes, our seat submitted.
POCSO case.
Then I will be approached.
Our seat submitted.
As per office note dated 21/8, service report is awaited. Post. Further, comma, the learned additional PP submits that in the meantime, upon completion of investigation, charge sheet has been submitted. Do you have the number?
Yes, Lordship.
Fight CS number?
My CS number 131/26, dated 28/7/26.
Next paragraph. The prosecution shall take instructions regarding the service upon R2 also. In the meantime, call for the scan TCR from the learned court below of comprising case diary and charge. List on
15th.
50,
It might take time.
Okay. 15/9.
Finding at vigilant.
May I please your lordship?
Okay.
My lordship, this is a case in which it is under section 4 of the POCSO, my lordship. 183 days as on date, my lordship. Out of 8 PWs, my lordship, 3 PWs.
Have been examined.
PWs, my lordship, and then the victim, the informant, and the MO. My lordship, here I take lordship. For example, page 13, my lordship, the FIR.
Page 13.
13, my lordship. My lordship, may be pleased to peruse, page, annex 1, page 13.
Page 13, yes.
My lordship, before I proceed, I just confirm the date. My lordship, it is lost on 23/2/2026, my lordship. My lordship, that is respectfully it is to inform you that on 22/2/2026, at around 4 p.m., my sister-in-law, Miss X, aged 17 years, 5 months, father of this, resident of this, who is a minor, while was walking towards this shop near the house, the above referred accused person along with one friend, by bringing their one small four-wheeler vehicle, forcefully by gagging cloth in the mouth, pulled her and took her in the car to Balitika village to a non-residing unknown house, and there Muhammad Nekibuddin had forcefully raped my sister-in-law. It is also to mention that they have threatened my sister-in-law to kill her if about the incident is informed to anyone. My lordship, this is the FIR, my lordship, where the cause of action, my lordship, was 22/2/2026. I take your lordship again to forwarding, which is at page annexer 3, page 20, where also the date of occurrence was reflected as 22/2/2026, my lordship. Then I take your lordship for a second to page 35. This is a statement under section 180 of BNSS of the victim, my lordship.
Page 30.
35.
35. Okay. Mhm.
Here, my lordship, my name and I'll read the relevant portion, my lord. My name and address mentioned above is true to my knowledge. I study up to class 8 from Balitika Nehru School on 22/2/2026. My lordship, at around 4 p.m., I went to buy iftar grocery things nearby shop. At that time, Nekibuddin of our village came and took me in a car by pressing my mouth. He took me an unknown house where he forcefully raped me, and later he dropped me on the way to my home with a threatening that he will kill me if I reveal the incident to anyone. Then I came home crying and I narrated all the incident to my sister-in-law, Rabia Khatum. After discussing with family member, my sister-in-law and my elder brother brought me at Laluk police station. My lordship, I take your lordship to the medical examination at page 39. The relevant portion, my lordship, at page 41. My lordship, for a second, page 39. 39, the medical examination was conducted 23/2/2026, the next day, my lordship. And at page 41, my lordship, is the opinion. My lordship has seen?
Opinion.
Opinion, page 41, the third no evidence of physical injury seen in body, my lordship, the opinion. It was done the next day. Now what happened was that, my lordship, in the statement before the 164 statement, my lordship, she has developed the date 22 to 21. I take yours, the statement is, my lordship, page 42. Page 42. The contents and allegations are same, where the date was developed to 21. So that the accused does not get the benefit of the medical examination, my lordship. My lordship, page 20, annexure 9, page 20. The contents are same, my lordship, and it comes to date 21. My lordship, in between, my lordship, I have given the evidence, my lordship. My lordship, may be pleased to peruse the evidence, my lordship. I take your lordship to the statement of PW2, my lordship.
In the record,
My lordship, I have given the certified copy, my lordship.
this is the evidence.
Evidence, MO, the victim and the informant is examined, my lordship.
Record only MO's evidence was there.
So in due course, my lordship, I have brought the certified copy.
Mhm.
My lordship, may I read PW2, the informant? I am the informant of the case. Victim X is my sister-in-law. I know the accused Nekibiuddin. Incident occurred about 6-7 months ago. At the time of the incident, my sister-in-law was about 17 years and 5 months of age. On the day of the incident, about 5 p.m., my sister-in-law had gone to a shop to buy something. Then accused came and gagged her mouth and lifted her into a car and took her to a house where he raped her and thereafter left her in front of a house. Around 7 p.m., threatening to kill her if she revealed about the incident to her family members. As per the FIR also, 4 p.m. she was taken, 7 p.m. she was dropped to the place. However, later on, my sister-in-law told me about the incident. Then we all family members went to the house of the accused in our village and informed the family members of the accused about the incident, and they told us to do whatever we thought was proper. So we went to police station and I lost FIR. Police later on recorded my statement as well as rest of victim girl and also sent her for medical examination, produced her before the court for recording her statement under 183 BNSS. My lordship, I read the cross. This is very relevant. The FIR was written by police. I do not remember the date of the incident. About 4 days before lodging of the FIR, the wife of the accused had lost a rape case against my husband. The wife of the accused is my own sister. At the time of the incident, it was Ramzan month. I had sent my sister-in-law, the victim X, to the shop to bring some food items for iftar. At that time, people go to masjid or for iftar. The place of occurrence from where my sister-in-law was lifted by the accused had houses of many people, including that of some names, my lordship. I did not see the incident myself. So, my lordship, through this FIR, I want to project that
4 days before the lodging of the FIR.
No,
Before the lodging.
before the lodging of the FIR, the husband of the
Wife of the accused had
No,
lost the
husband-
rape case against the
husband-
informant's husband.
husband was already behind the bus 4 days. 4 days before lodging of the FIR, means this FIR, my lordship. The wife of the, I have annexed that FIR also, my lordship. The wife of the accused had lost a rape case against my husband. The wife of the accused is my own sister at that time, my lordship. Then I take your lordship to the victim statement, because others are, my lordship, denial part. It is not a, but I want to show that prior to 4 days of the incident, my lordship, an FIR was lost against the husband of the informant. In a way, the brother of the victim, my lordship. Again, I take, lordship, I take to the statement of the victim. My lordship, I take directly to the cross. That will be more relevant, my lordship. I do not remember the date of incident. I was, my lordship,
Yes, I found it.
I do not remember the date of the incident. I was lifted away from the village Balitika by the accused from near the house of Azizur Rahman before I reached the shop. I was not able to raise hue and cry as the accused gagged my mouth with his hand. I did not notice the registration number of the car or the color of the vehicle. I do not recognize the driver of the vehicle. In the month of Ramzan, people go to masjid before sunset. At that time of the incident, I was 4 days before the incident, the wife of the accused had lodged a rape case against my elder brother Soriful Islam. He has been arrested and taken to judicial custody. At that time, accused committed the incident with me. 9 and 10 are, my lordship, denial. It is not a fact that I did not state before the magistrate the accused had threatened to kill me if I reveal about the incident to my family members. This was not stated. It is not a fact. Then, my lordship, this 11 is very important. My family members had gone to the house of the accused to request the accused and his wife to compromise the case given by the wife of the accused upon my brother, but they did not agree to compromise the case. So, my lordship, what I want to project from the 4 days, from the FIR, from the forwarding, from her statement before the IO, the cause of action or the date of action, lordship, was occurrence was 22/2/2026. The FIR about they are stating, I have annexed at page 28 in my petition, my lordship. That was lost on 19. So
Right.
9.
I've understood. So,
So, my
just show me that FIR against the brother of the victim girl.
my lordship, page 28.
No, this is the FIR against your side, against your side.
My lordship, Annexa 5, page 28.
No, this is the FIR in which bail is being sought.
No, my lordship, the bail has been sought in Annexer 1, page 13.
Oh, sir, this is different. Sorry, this is different.
Yes.
Let me
this-
read this.
Yes.
This is dated.
My lordship, this is stated, my lordship, if my lordship peruse page 30, the date is written, page 30, the original 19/2/2026. Exactly 4 days, my lordship.
Got it.
So this was 19.
She is married to the.
This is.
She is married to the accused.
Yes, my
present
lordship, accused wife. And
Wife of the accused.
wife of accused, and she has lost FI against the husband of the informant exactly 4 days prior to the incident.
Husband of the informant.
Yes, husband of the informant.
Anyway.
And my lordship, the cause of action and the date itself also was reflecting 22/22. But when the medical benefit status came in, they have changed the date to 21.
Okay, let me hear the other side.
Yes, my lord.
As per a statement before the
But the
183.
per prime facie, the possibility of false implication cannot be ruled out because it has come in record, isn't it?
Only the evidence part is not here.
When is he? He's in custody since?
My lordship,
Not
as of
as
date,
from 21.
my lordship, as of date,
20
183 days, he is custody since
23.
23, my lordship.
23 to
2026.
He should be. What do you say? Sir? We should. I think we should consider at least this.
In this case, lordship, trial is proceeding, lordship. There is no prolonged delay or prolonged detention in this case, lordship. And there is admittedly a family dispute between the two.
Serious family dispute, I mean, family dispute should not result in POCSO cases if it is true.
Lordship,
These are serious matters, actually. That itself is you're appearing as amicus. Because we do not know, because it is a matter of record that there was a case which was filed.
lordship, there is a risk of threatening the victim also.
That we have brought. to
If both the
evidence.
incidents are true, then it's very unfortunate. Anyway, third, S.G. Borua, learned counsel to the petitioner, have a seat. D.P. Goswami, additional PP, and Miss P. Sharma, right?
Lordship.
Mr. Sharma, learned amicus representing the informant. Invoking 483 BNSS, the petitioner herein, namely, when so, Nekibuddin is seeking regular bail in connection with special POCSO case number 28 of 2026 under so-and-so section, I've underlined. And which is stated to be pending before the court of the special judge POCSO, not Lakhimpur. Full stop. The case had arisen out of an FIR dated 23/2/2026, closed by the sister-in-law of the alleged victim woman, resulting in registration of Laluk PS case number 50 of 2026. The petitioner was arrested on 23/2/2026 and continues to be in under trial detention. Ms. Borua, Learned Counsel, has taken the court through the statement of the girl recorded by police as well as before the learned GMFC. The case is stated to be at the stage of trial and prosecution witnesses have been examined. 8 witnesses are listed in the charge sheet. The petitioner, the Learned Counsel for the petitioner has submitted before the court a certified copies of the depositions of the informant, the MO, and the victim. It is revealed from the depositions that 4 days prior to the lodging of the instant FIR and another FIR dated 19/2/2026 was lodged by the wife of the present accused against the husband of
The informant.
the informant alleging commission of rape. It has also been revealed from the materials, including the testimonies of the witnesses, that there was an attempt at compromise of the matter, which was refused, and whereupon there was a threat to lodge a false case. The court cannot express any opinion on the merits of the matter as the same is undergoing trial. Next paragraph. But nevertheless, considering the, sorry, you just right, the learned additional PP submits that per se, though allegations have been made for offenses under the POCSO Act, but the said aspect of the previous case does emerge from the materials. In the materials projected from the petitioner side, Ms. Sharma, the learned amicus, submits that the trial is not yet completed and there are apprehensions about manipulation of witnesses upon granting of bail at this stage, and therefore the learned amicus curiae opposes the bail at this stage. Next paragraph. I perused the materials and considered the submissions. Next paragraph. That line you insert, express any opinion on the it's undergoing trial. That line, place it here. Place it here. Court cannot express any opinion as the matter is undergoing trial. Next paragraph. However, considering the length of detention, the progress of trial, and other attendant facts and circumstances, the accused should be granted bail at this stage. In such view of the matter, 30,000 with 1 surety of the like amount to the satisfaction of the learned special judge North Lakhimpur, and subject to the condition that he will be available for the remaining trial and shall not hamper or tamper with evidence. Bail petition stands allowed and disposed of. This you would like it back?
My lordship, it can be part of record.
Lordship, strict restrictions may be.
Yes, yes. The petitioner shall not cause any harassment, harm, or intimidation upon the victim in any manner. Violation of the bail conditions would make the bail liable to be cancelled. The certified copy of the deposition submitted shall be part of the record. Okay.
Obliged, my lordship, highly obliged.
Time being has, no? Yes.
19.
Mr. Rahman, come.
Take your lordship, my lord. For officially 21/8/26 service report is awaited. So take the instruction regarding service at least.
Only, my lord, I have been arrested on 16/1/2026, my lord. That is more than 7 months more, my lord. And what is interesting is that, my lord, here in this case, my lord, PW1 complainant and the victim, PW2 has also been examined, my lord. And I just want to take your lordship to my lord. Annexure D, page 28, my lord. Order dated 21/7/2026, my lord, wherein, my lord, the learned special judge Udalguri has observed mechanical observation, my lord, which is disturbing, my lord. That is on page 29, my lord, on the last para, my lord. I'm just reading out the the disturbing mechanical order before lordships, kind convenience with lordship permission, my lord. This court is accordingly of the opinion that the accused and the victim girl being neighbors, the release of the accused on bail may aggravate this situation. I emphasize, may aggravate the situation in the locality and may cause harm to the life, liberty, and reputation of the victim girl in the future. Therefore, this court is not inclined to allow the accused Vishnu Sutra to go on bail today, and hence his prayer for bail stands rejected, my lord.
Hmm.
And this is the mechanical observation, my lord, which is uncalled for, my lord. And I have been already, my lord, 5 witnesses have been examined, PW1 to PW5. The victim has already been examined.
Okay, that's good.
And there is no question of, my lord, hampering or tampering with the evidence, my lord.
Achha, this,
CRPC has given a lordship
Mr.
ample
Rahman,
power.
we have to, take steps since it's a POXO case. The step, what did you say?
Service they waited as per office notice 21/8/26. So we take instruction regarding.
No. The steps of steps of notice have not been received. Yeah, you have taken steps.
My lord, my lord.
You have taken, but kindly check with the registry. You have some because they have the office note says that steps for issuance of notice upon respond number 2 has not yet been received by the registry as yet. Kindly check with the registry,
My lord,
and
my lord.
once the steps is there, they will take instructions. Okay,
My lord.
kindly check it today only. You just check it with the
I just
registry.
pray for a lordship short date, my lord.
Okay, no problem. And then once the notice is sent, they can take the this thing.
I'll
It's in
oblige.
Udalguri district. When will you give it? Date? Third of this next
I'll
week.
oblige, my lord. Shall be ever so.
Please, your lordship. This is regular bail
This
application,
case-
lordship.
This case did not receive, my lord. No, I was sent a report, my lord. He has received the requisition only today, so my lord, he prayed for some time.
My lord, my one submission, lordship, and the petitioner was arrested on 1/7/2026 as on today, lordship, 56 days, lordship. And kindly come to prayer for a moment, lordship, FIR.
Section 87 is 498A earlier.
No, lordship, this kidnapping, lordship,
366.
366. So apparently, lordship, the otherwise, lordship, kindly come to FIR, lordship, is 11, lordship. Translated copy, lordship.
May fix any short date.
Otherwise, lordship, and there is nothing, lordship, and the informant, lordship, in the here, lordship, and they have already been settled, lordship. And the victim is voluntarily eloped with the petitioner, lordship, and subsequently handed over to the informant, lordship, and lordship, for a moment, lordship, kindly page number
Minor.
21, lordship.
Yes.
The page number 21, the lordship, third para, lordship. May I read, lordship, for
Just a minute. Let me come to it.
there is no case at all, lordship. And para number third, lordship. Accordingly, the statement of the victim girl has been recorded under section 183 BNSS. After giving her adequate time for reflection, let the same kept in the sealed and enveloped so and so, lordship. The victim has eloped, so the victim has deposed voluntarily. Actually, it should be and oath and administered to victim, and she deposed voluntarily on oath without any force or coercion, lordship. So, well, there is.
I would have liked to see the statement of the girl at 168, 183. That would support your case. That is your
That
contention.
has already been settled,
Can
lordship, and the informant is here,
You
lordship.
also here. Oh, the girl has been recovered. What is your submission? You're not opposing the bail. They had a love affair, but she's very young actually. She has to study and complete her majority at least. Anyway,
Short date, my lord, after today, I can put let the
can be allowed.
6 days, lord,
And
statement of the victim.
since he's all not opposing, no problem. 56 days only, it will be over. Mr. F. Hawk, Learned Counsel. Thakur, and your Mr. A. Sharma for the Learned Counsel was entered appearance for the informant. Full stop. For the informant, right? The affidavit is on record here. Have you you file an affidavit also? Yes. Invoking 483 BNSS, the petitioner is seeking regular bail in connection with Soigao 121 of 26, the 87 of BNSS. The case arose out of an FIR dated 19/6/2026, 10/6/2026, alleging that on 6/6/2026 in the late evening, the informant's daughter left for one educational institution but went missing. Thereafter, he received a phone call from one number asking for an Aadhaar card. As for the forwarding report, forwarding the arrested person, Saidul Islam, the present petitioner, stated to be aged 21 years. Girl has been recovered and as per order dated 6/7/26 passed by the learned magistrate, she has also been, for her statement on the 183 BNSS has also been recorded. Mr. Sharma, Learned Counsel, for representing the informant, submits that it's a case of elopement and that parties have settled the matter and the informant does not oppose the bail. Petitioner was having been arrested on 1/7/2026, stated to have completed 56 days in under trial detention. The applicable statutory period is 60 days. In the given facts and circumstances, I allow this bail petition and the petitioner is hereby allowed to go on bail of rupees 50,000 with one surety of the like amount with the satisfaction of the
CJM Kamrup Amingao.
CJM Kamrup Amingao and subject to the conditions that he shall cooperate with remaining investigation. He shall not cause any harm, annoyance, harassment or intimidation to the victim girl in any manner. Also, violation of the bail conditions will entail bail cancellation. Bail petition stands allowed and disposed of.
Deeply obliged.
21, my lord, service report not yet received.
Yeah, no. As per office note dated 21/8/26, service report is awaited upon R2. The prosecution shall take instructions regarding the same. Scan record is however available. List on
7th of 7/9.
okay 7/9.
Obliged, sir. Ready to
Here in this case, Lordship, apart from that 36 notice, the another ground is that, Lordship, the entire seizure process was conducted on, Lordship, may kindly turn to page 15. 15. On 21/5/2025.
Page?
Page 15.
15.
15.
Okay.
Here, Lordship, that in initial information received on 21/5/2025 at 11:30 AM.
Hmm. Okay.
Yes. And subsequently, Lordship, they were conducted NACA checking, and during NACA checking, they apprehended the track of the present petition and allegedly recovered those contraband. Now, if your Lordship kindly see that seizure list that I am placing, page 26 is the vernacular.
What a suspected heroin,
Heroin.
right? 1 kg, 236 grams. Page,
Page 26. Date and time of seizure 21/5/2025 at 2 PM.
can you repeat the page number, please?
Page 26.
Okay. This is the seizure.
So after initial inquiry, they seized those articles and formal seizure list was prepared at 2 PM. So prior to that, he was detained and seizure was made.
Hmm.
So now if your Lordship turns to the forwarding report, that your Lordship will find page 33.
Hmm.
He was forwarded on the next day,
This is the forwarding report.
page 33.
Hmm. Yes, yes.
That is forwarding report dated Lordship 22. The date Lordship will find at page 36. Last part of the forwarding report. Signature 22/5/2025. So next day, I have checked the records, Lordship. Record shows that they left from the PS at 2:30, after 2:30 to after 2:45 PM on 22/5/2025.
Excluding the journey is available.
Yes, that is why, Lordship, I
That
am
is-
not saying at what time he was produced. So I am only saying the part from when they started their journey from the PS. They started their journey from the PS at 2:45 on 22nd.
On 22.
On 22.
You have to see that part. And
And that 36 notice, Lordship, that signature is not there. And therefore, Lordship, his initial detention period has to be mentioned there, but they have written a wrong date. Therefore, that not taking the signature of the independent
the
witness.
36 notice is at page
Page 56, Lordship.
56.
Although they have apprehended me, Lordship, in the morning hour, but
11.
they have mentioned here time as 11:30 PM.
11.
And therefore, signature of not taking signature of the independent witnesses from that locality has caused prejudice to me, Lordship.
Follow these things anyway.
And regarding this, Lordship, that putting wrong date in the arrest memo, Lordship, that has also been discussed by this honor by coordinate bench of this court, Lordship.
The wrong date in the arrest memo, they put what date in the arrest memo?
They have mentioned as 11:30 PM.
PM.
But I was apprehended in the morning hour, Lordship.
No, but the arrest memo, this, the forwarding also mentions as
But
11:30
the
PM.
independent witness signature is also
But
not.
here also 11:30, FIR also 11:30 AM.
FIR is at Lordship
11:30 AM, here it's PM.
PM. Initial information
that's
was
a-
11:30
Is it
AM.
a typographical error? 11:30, this is 11:30 AM FIR, right?
It is also mentioned.
And then in the forwarding, which we just saw, it is mentioned as
PM.
2 PM. 10:30 AM and PM, date of seizure. Seizure is 2 PM. Okay, anyway, let us see.
Forwarding AM, Lordship.
Anyway, you make your submissions, prosecution.
In this case, Lordship, that he was arrested on, he was
detained on lordship, that is 21/5/25 at 11:30 PM. Lordship. Mentioned as lordship forwarding and lordship and arrest memo lordship, as mentioned lordship. And apart from that lordship, in the seizure lordship,
Seizure was at 2 p.m.
there was 2 PM lordship. But only that in lordship in the FIR lordship, it is shown as, it is mentioned as lordship 11:30 AM lordship.
That is no information was received. I was wrong actually.
Lordship.
Information was received at
Information
11:30 a.m.
AM.
It was received. Information was received. I was slightly mistaken. Anyway,
And seizure list was prepared on the same day at 2 p.m.
this commercial quantity.
Commercial quantity.
Let me see 37.
So that time has to be calculated from that detention period. Your lordship's order is also there, lordship. On the other day also I have.
He was
placed.
detained at 11:30.
He was detained at around 12 p.m. noon, lordship. And seizure list was prepared at 2 p.m. So even if we go by that seizure list also, that exceeds 24 hours.
My humble
We
submission
cannot
is
be
that lordship,
hyper technical in these serious matters. Anyway,
lordship, my humble submission is that lordship, here in this case lordship, seizure list lordship may kindly come to, there are 2 seizure lordship on the same day, that this
Page?
person and another driver, that is page 31.
Okay.
Page 31, that is another person was being detained lordship at the same time lordship. Earlier that this person was, this seizure was made at 2 PM. Thereafter, that the driver from the
3:35.
driver, it was he was seizure was made at 3:35 PM.
3:35 p.m.
The question is that lordship, and the next question comes lordship, when he left for the judicial court lordship, and that is lordship immediately at 2:45 PM. That is mentioned in the IO note lordship, in the CD lordship. So lordship, if we go by the first seizure list, then it exceeds the 24 hours. But at the same time, when 2 persons are being detained, on the same cases, lordship, on the same nature of case offenses, and the same on the same case, and 2 person was detained. 1 person is being seizure was made at 2 PM because it needs some time, and thereafter from at 3:15 PM, this needs some time, lordship. So lordship, and police cannot. It is not the case, lordship, that police will go by one. You have come first, then you go to the court below first. Then you have come second, then you go to the court below at second time. So lordship, if you calculate the time from the second lordship, that's the final seizure list lordship, then it is within the 24 hours lordship. That is page 31 lordship.
Formal arrest is at 11:30 p.m.
Formal arrest is 11:30 PM lordship. So lordship, at this stage lordship, that lordship, that arrest memo says-
Seizure witness statements are here. Seizure witnesses. A huge quantity of
statements are there.
heroin. Huge quantity. It's what 1200 grams. It is 5 times more than the commercial quantity.
lordship.
Seizure witness. Let me see.
And lordship, in this case lordship, only the search has been framed lordship on 19/1/26, and thereafter lordship updated, the updated CD was also called for on that day lordship. 19/1/26 is the updated CD lordship. Thereafter no updation is here lordship. So at that time lordship, updated CD is also required lordship.
The submission which my learned friend has made that it took time to prepare the seizure memo as per section 58 of BNSS, lordship, only the journey time is excluded. The other part is not excluded.
Also,
And
I'm
that
not
said,
submitting lordship, that time is not, I'm not submitting lordship. I am submitting that lordship, one seizure was made from 2 persons were detained at on the same vehicle, they were coming. One person was one seizure was made from 1 person at 2 PM, and second person was that second seizure was made at 3:35 PM lordship. So lordship, we have the time to as both persons were, if you calculate the time lordship, that is second from the second lordship, then we have the time till 3:35 PM lordship, and only because of that much time lordship, that discrepancy lordship, that this case is not maybe allowed. This case
For this
cannot be allowed
in the
lordship, because
morning
lordship,
hour itself,
No,
but
no,
they
we
have
have
not
to-
done. And by your lordship and other coordinate bench also, lordship clearly held it will be counted from the initial detention, Lordship.
But it has to be from the records.
Yes, it is from the
We
record.
cannot
that-
take a hyper-technical view in these serious matters, you know.
No, I am not.
1250 grams of heroin, you know, if it is,
When Lordship
if it finds way among the youth, what will happen? You know, we have
No,
to
when
think
Lordship
of this.
constitutional right is violated,
No,
Lordship,
you-
then Lordship may kindly see that Caesar list. Caesar list they shows Lordship at 2 p.m.
Our division benches also indicated about this, that holistic view has to be taken. You know. Only a few, yes, they should take the signature on the, that is not an excuse. Why should IO not take signature on the arrest memo? They should take. But that in itself will not, you know, defeat.
When in the, that
Only on
mandate,
36, Lordship. I am on that, Lordship, that I have not been produced within 24 hours. That
Yeah,
is a
I mean,
separate ground. That
Learned
director,
Counsel,
director of enforcement, Madam Subhash Sharma, Lordship.
when Lordship in DK Basu
Case
case,
para,
Lordship,
sir, full stop, learned counsel for the petition, additional PP for the state. Invoking 483 BNSS, the petitioner is seeking regular bail in connection with this. Have a seat, take some time. Alright, we'll go. The initial part of the petition, where is it gone? No, the initial part of the petition. Nice one, the page 7. The part 2 could go. Petitioner bottom cost title to. Do you have the cost title in your petition?
we have,
You have?
proceeding we have, Lordship.
Hmm?
We have,
Oh, sorry, it's gone inside me. In connection with, have a seat, please. Special NDPS case number 60 of 2025, pending before the learned special judge Tribune. The petitioner was arrested on 22/5/2025. We'll stop. The aforesaid special case arose out of Karimganj PS case number 250 of 2025 under section so-and-so of the NDPS Act. The allegation in the FIR was that based on a source information, a search operation was undertaken in vehicles, whereupon in vehicle and truck bearing registration number AS26 AC 0816, which was escorted by another vehicle AS26 AC 0664, traveling from Badarpur to Pathargandhi via Sri Bhumi bypass. Stop. During the Naka checking, the targeted vehicle AS26 AC 0816 was intercepted along with the other vehicle. And after a search operation was conducted in the presence of independent witnesses. The search revealed 110 number of soap cases containing suspected heroin weighing 1236.35 grams. It was the said suspected heroin was concealed in the body of the vehicle, which was being driven by driven by Joinal Uddin alias Joinal Hussain, full stop.
Co-accused is granted bail. That order is at page 50, Lordship.
The investigation of the case resulted in a charge sheet and registration of the special case, and which is stated to be at the stage of trial. Trial evidence is on now.
Evidences are Lordship, here in this case, Lordship, TCR is updated till 9/1.
How many witnesses examined?
Not, we cannot say Lordship because TCR is not updated. Here is updated Lordship till 19/1/26 Lordship.
The learned counsel, Mr. Ahmed, submits that the petitioner was detained in the morning hours. And by the time he was produced before the learned magistrate, the time period of 24 hours had already exceeded. Full stop. It is also pointed out that in the arrest memo under section 36 BNSS, the signature of witnesses was not taken. Full stop. The scan PCR is available, and I perused the relevant materials therefrom. Full stop. Next paragraph. With regard to heroin, the stipulated commercial quantity is quantity above 250 grams. Full stop. Therefore, clearly the alleged quantity in the instant case falls way above the stipulated commercial quantity. Full stop. I perused the memo, one of which is at 2 p.m. and the other at 3:35 p.m. There were 3 trucks, right? There were 3 trucks.
2 trucks.
As per the notice under section 36 BNSS, the time of arrest is indicated as 11:30 p.m. Full stop. Where is the production order?
That order I have not annexed.
Anyway, so
It is there in the record, Lordship.
I perused the seizure memos annexed with the bail petition. Full stop. The relevant portions of the case record have been gone through, including the statements of the 2 seizure witnesses, both of whom have fully supported both of whom have stated about being participant in the search operation, during which the alleged contraband was discovered and seized. Full stop. They have stated that the seized drugs were found in cartons which were sealed with LWH. Peruse the inventory documents pertaining to the seizure and sampling. Full stop. Also peruse the forwarding order, remand order dated 22/5/2025.
One GD entry is also there, Lordship, regarding when, Lordship, they have left from the PS mode.
I peruse the grounds of arrest enumerated in the notices under section 47 and 48 of the BNSS. Peruse the seizure list enumerating in detail the seized materials. The quantity of the suspected heroin is stated to be 1 kg 236 grams. Upon perusing the entire materials, the court is unable to find that there are no reasonable grounds to believe that the accused persons are not guilty. Therefore, the statutory bar under section 37 would be applicable at this stage. And the bail cannot be granted in view of the said restrictions. Full stop. Accordingly, the instant bail petition stands rejected at this
So,
stage.
one thing, if I may,
However, the learned trial court shall endeavor to expeditiously complete the trial. Yes, please.
One thing, I have not argued on merit of the case, but I am only on that, Lordship, I
Yes.
was not produced within
Mm.
24 hours.
Yes.
And that independently, Lordship, is violation of Article 22, and which entitles me of bail under, in terms of, Lordship, that Director of Enforcement versus Subhash Sharma, Lordship. I was arguing on that point, Lordship.
No, I've seen the merits. There's nothing to see, actually.
There may be a case, but when, Lordship, constitutional rights are violated, that section 37 will not come.
We have to protect the society from this huge contraband. We have to protect the society. Recently, in some places in Assam, there have been demonstrations by public against drug menace. We have to protect the people. That is also a constitutional duty. You can approach the court.